Okay, picture this. You wake up one morning to find your entire town has been legislatively teleported to a completely different province, just weeks before a major election. You didn't move, your house didn't move, but the map line? It sure did. That is exactly what happened to the people of the Matatiele Municipality in South Africa. In this explainer, we're unpacking a truly fascinating piece of constitutional history, Case CCT 73/05, Matatiele Municipality versus the President of the Republic of South Africa. Ultimately, this is a story about maps, political power, and most importantly, the voice of the people. We're going to break this compelling story down into 6 quick parts. A town changes provinces, who draws the lines, the constitutional challenge, a massive procedural plot twist, divided judicial opinions, and finally, what happens next.
Let's kick things off with part 1, a town changes provinces.
So, Matatiele has a pretty complex, decades-long backstory. Way back in 1978, the Steyn Commission recommended separating the urban Matatiele area from the rural Maludi area. This was based on the old apartheid policy of separate development. Post-apartheid, the 1995 Trengove Commission had to look at those borders all over again. By the year 2000, things seemed settled when the Independent Demarcation Board officially established the Matatiele Municipality inside the KwaZulu-Natal province. But then, in 2005, the government passed the 12th Amendment to the Constitution, and literally with the stroke of a pen, Matatiele was pulled straight out of KwaZulu-Natal and dropped into the Eastern Cape.
Now, here's where the timeline gets incredibly stressful. This constitutional challenge wasn't just a leisurely debate. It was filed just 2 days before Christmas in 2005, with local elections looming in less than 3 months. You can imagine the absolute panic on the ground. The people of Matatiele, alongside local farmers, taxi associations, and the Chamber of Commerce, they rushed straight to the Constitutional Court. They had just been told they would be voting in a totally different province, and the clock was aggressively ticking down to March 1st.
Which brings us to part 2, who draws the lines?
To really grasp this, we have to look at the strict separation of powers here. Under the Constitution, Parliament is the only body that can alter a provincial boundary, and they have to use a very rigorous constitutional amendment process to pull it off. But on the flip side, the Constitution intentionally created the Municipal Demarcation Board as an independent, nonpartisan authority to draw the local municipal boundaries. The whole point of the board is to guard against political gerrymandering.
And the board doesn't just draw lines on a whim. Because it's made up of experts in town planning, geography, and economics, they use intense, objective criteria. They're looking at commuting patterns, where people actually spend their money, topographical features, and financial viability. The applicants in this case argued that by passing a constitutional amendment to move their town, Parliament completely bypassed all these objective criteria and essentially stomped right over the board's independence.
But, to be fair, the government wasn't just doing this for fun. They had a clear, practical motive. They enacted the 12th Amendment to eliminate the absolute nightmare of administering cross-boundary municipalities. You see, before 2005, some municipalities literally straddled the border between 2 different provinces. This required what was called a joint administration model. Imagine trying to run a town where a politician from Province A has to agree with a politician from Province B on every single thing, while health, housing, and traffic control are administered completely separately by each province. It led to massive financial burdens and completely stalled service delivery. The government's goal was simple: one municipality, one province. No more messy overlaps.
So we hit part 3, the constitutional challenge. The core of the applicant's argument was this. By moving the town to the Eastern Cape, Parliament illegally took over the board's specific job of redetermining municipal boundaries. They essentially said, look, Section 155 of the Constitution says the independent board handles local boundaries. By passing the 12th Amendment, Parliament effectively redrew our local borders to fit into a new province. That is a hostile takeover of the board's constitutional powers. Well, Justice Ngobo stepped in with a bit of a reality check. He ruled that Parliament didn't steal the board's job at all, because altering a provincial boundary inherently and legally requires adjusting the local municipalities within it. It's based on this legal doctrine called implied powers. If Parliament has the express power to alter a provincial boundary to get rid of cross-boundary municipalities, it absolutely must have the implied power to shift the local municipal borders that sit right on that line. The court unanimously agreed that Parliament did not usurp the board's authority here.
But wait, because here comes part 4, the procedural plot twist.
Just when it looked like a closed case for the government, we hit a massive complication. The Constitution requires that provincial legislatures facilitate public involvement before approving any boundary change. Section 74(8) explicitly says if a bill concerns a specific province, that province's legislature must approve it. And Section 118 says a provincial legislature must facilitate public involvement in its processes. Now, the applicants actually conceded originally that the proper procedures were followed, but during the hearings, the judges noticed something glaring in the paperwork.
And this is the bombshell. Unlike other provinces, the KwaZulu-Natal Legislature failed completely to ask the people of Matatiele what they thought before passing the amendment. While provinces like the Eastern Cape, Gauteng, and Limpopo were out there holding public hearings, taking written submissions, and even using local radio to invite people to speak, the KwaZulu-Natal Legislature did absolutely nothing of the sort. They simply approved the boundary change. They essentially signed away the town of Matatiele without asking the people who actually lived there.
This sudden procedural loophole sparked Part 5, Divided Judicial Opinions.
You had Justice Sachs coming out swinging for transparency. He passionately demanded government candor, emphasizing that a lack of public consultation creates an information deficit that threatens the very rationality of the law. He noted that the rule of law requires a culture of justification. If you just move a town without asking the residents, you aren't governing by openness. You are regulating by arbitrary force. Without public input, the court is left entirely in the dark about the true motives and impacts of the law.
On the other side of the bench, Justices Skweyiya and Yakub took a much more pragmatic approach in their dissent. They argued that since the applicants didn't originally raise this procedural issue, the court shouldn't delay imminent elections to figure it out now. They pointed out the sheer unprecedented chaos of stopping an election at the 11th hour. Think about it. If the elections were halted in Matatiele, who would even administer the town? The Eastern Cape or KwaZulu-Natal? The administrative nightmare of pausing the election would be worse than the boundary issue itself.
This presents the ultimate balancing act for the highest court, right? Strict adherence to democratic openness versus the very practical realities of governing and running elections on time. Justice Ngobo and the majority ultimately decided that it is not in the interest of justice to embark on a judicial frolic right before an election, especially for an issue this complex. However, because the Constitution is the supreme law of the land, they couldn't just ignore the fact that the KwaZulu-Natal Legislature might have seriously violated it by ignoring its citizens.
Which leaves us with Part 6, what happens next? With the clock ticking, the court basically hit the pause button on the final legal verdict. They ruled that the March 1st elections must go ahead to avoid total chaos. The people of Matatiele would have to go to the polls and vote under the new Eastern Cape boundaries. But, and this is a big but, the court ordered the speakers of the provincial legislatures and the Electoral Commission to return on March 30th. They had to come back to answer exactly why the public was ignored and whether that failure renders the 12th Amendment completely invalid.
As we wrap up this explainer, it leaves us pondering a really profound question. If a law is passed without the people's voice, is it truly the law? The Matatiele case proves that the procedures of participatory democracy, the messy, time-consuming business of holding hearings and actually asking for public opinion, are just as important as the outcomes. When those steps are skipped, even the highest laws of the land can be shaken to their core. It is definitely something to think about the next time you see a local public hearing notice pinned up in your town.